Hello and welcome to today's episode of The Probate Process in Massachusetts. Today, we will be discussing the probate process in the Commonwealth of Massachusetts and the possibility of selling estate property before the probate process is complete. The probate process in Massachusetts. Let's start by understanding what the probate process is. Probate is a court-supervised process for transferring a deceased person's assets to their heirs and beneficiaries. The process involves several steps, including filing a petition for probate, appointing an executor, and notifying interested parties. The steps involved in the probate process in Massachusetts. The following is a brief overview of the steps involved in the probate process in Massachusetts. First, file a petition for probate. The executor or personal representative files a petition to open the probate case with the Massachusetts Probate Court. Second, appointing an executor. If the deceased person left a will, the court will appoint the executor named in the will. If there is no will, the court will appoint an administrator. 3. Notify interested parties. The executor must notify all interested parties, including heirs, creditors, and beneficiaries, of the probate proceedings. 4. Inventory and appraise assets. The executor must inventory and appraise the deceased person's assets and submit a report to the court. 5. Pay debts and taxes. The executor must pay the deceased person's debts, including any outstanding taxes, before distributing assets to the heirs and beneficiaries. 6. Distribute assets. After all debts are paid, the executor must distribute the remaining assets to the heirs and beneficiaries according to the will or the state's intestacy laws. 7. Closing the probate estate. The executor must file a final report with the court, indicating that all assets have been distributed and all debts have been paid. The court will then close the probate estate. How much does a typical probate process cost in Massachusetts? The cost of a probate process in Massachusetts can vary widely depending on several factors, including the size and complexity of the estate, the amount of assets involved, and the fees charged by the executor or personal representative. However, on average, a typical probate process in Massachusetts can cost anywhere from 2 to 5% of the total value of the estate. Here's a breakdown of some of the typical costs associated with the probate process in Massachusetts. Filing fees. There is a fee for filing a petition for probate, which could be about $375. Attorney fees. If you hire an attorney to assist with the probate process, you can expect to pay anywhere from $2,500 to $10,000 or more, depending on the complexity of the estate and the services provided by the attorney. It is a good idea to get fees in writing. Executor or personal representative fees. The executor or personal representative is entitled to a fee for their services, which is set by Massachusetts law. The fee is based on a percentage of the value of the estate, ranging from 1.5% to 3% for simple estates to 5% or more for larger, more complex estates. Appraisal fees. If any of the assets in the estate need to be appraised, there will be a fee for the appraisal services. Estate taxes. Depending on the size of the estate, there may be estate taxes due, which must be paid before the estate can be closed. In summary, the cost of a typical probate process in Massachusetts can range from a few $1,000s to several tens of thousands of dollars, depending on the size and complexity of the estate. Selling estate property before probate is complete. As we are not attorneys or financial advisors, this informational video is based on our own research and recommend doing your own due diligence. Now let's talk about the possibility of selling estate property before the probate process is complete in Massachusetts. Is it possible to sell estate property before the probate process is complete? Good news. Yes, it is possible to sell estate property before the probate process is complete in Massachusetts. However, there are certain requirements that must be met in order to do so. Here's a brief overview. Court approval. The executor or personal representative must obtain court approval to sell any real property before the probate process is complete. Provide a reason for the sale. The court must be satisfied that there is a valid reason for the sale, such as to pay debts, stop monthly occurring bills and maintenance, or to distribute assets to the beneficiaries. Notice to interested parties. The executor must give notice to all interested parties, including heirs and creditors, of the proposed sale. Fair market value. The sale must be for fair market value, and the court must approve the sale price. Sale process. The sale process must be conducted in accordance with Massachusetts law, including any applicable bidding requirements or restrictions on the method of sale. In summary, Selling estate property before the probate process is complete in Massachusetts is possible, but it requires court approval, the approval of interested parties, and the sale must be for fair market value and conducted in accordance with the law. That's it for today's episode of The Probate Process in Massachusetts. I hope you found this information helpful. If you have any further questions, and would like to receive a cash, as is, offer on the estate's property, feel free to reach out to us. Thank you for tuning in and have a great day.